That's the subject of our first question from Melanie. She wants to know, Holly, what if there's a custody arrangement, but during this pandemic, one parent takes social distancing very seriously and the other encourages the kids to sort of ignore it? Is there anything that can be done so that the first parent can maybe stop doing that?
I think that's such a complicated issue. I mean, it's one that I'm seeing a lot, that the courts are seeing a lot. I mean, just in your daily life, you can see when you go around with friends and family, everybody has a different opinion about what their level of comfort is. And when you're dealing with children, if you're the primary custodian, or if you maybe have a immunodeficiency or something like that makes you extra cautious, it's possible that your former spouse is just not in that situation. They don't have the children all the time. Maybe they just want to get out and blow off steam, go to possibly indoor restaurants and places that some people do not feel comfortable going. While I don't know if there's an easy answer to it, the primary custodian in theory does have final decision-making authority, but usually when a child is in one parent's custody, that parent gets to decide day-to-day things like where are they going and what are they doing. I have
Holly, but you know, as far as personal injury and most of the majority and premise liability, that kind of thing with civil work right now, it's very difficult to have a trial, get a hearing. Is that the same for family law? If in this situation, for example, if somebody is worried, how do you get a hearing or what do you do?
Family law, I mean, the courts are still open. Family law has still been trucking along. So, criminal trials are stopped. Personal injury, a lot of civil trials, those are stopped as well. But because family law is just in front of a judge, generally speaking, you are able to get a hearing.